The Suez Canal is a thin 200-kilometre long strip of water in Egypt, and it's one of the most important waterways in the world. It allows shipping to get from Asia via the Indian Ocean through to the Mediterranean and the North Atlantic without going all the way around Africa. It's always been owned by Egypt, but for decades and decades it was operated by a French and British company that took most of the profits. In 1956, the president of Egypt, Abdel Nasser, nationalised the canal, booting out the French and the British company and installing his own. Britain, France and Israel all attacked, and while they experienced military success, they completely lost politically because Nasser just began sinking ships to block trade in the canal. About the same time, Nasser began nationalising other companies, including the manganese mine owned by the Sinai Mining Company, later called Anisminic. They were forced to sell their mine to an Egyptian company, although they did get £500,000. Egypt later agreed to provide the British government with a pool of money to compensate British companies whose assets had been nationalised. The British government then established a scheme to distribute that money. Anisminic applied, but they ran into problems because the commission held that the Egyptian company which had bought the mine was the successor in title, and because they were not British, they were not eligible to apply. The appeal before the House of Lords really turned on the meaning of those words, successor in title. Their lordships found that the decision-maker had not understood the words, and that this was an error of law which led to their decision being a nullity, being no decision at all. Lord Reid said, "There are many cases where, although the tribunal had jurisdiction to enter on the inquiry, it has done or failed to do something in the course of the inquiry which is of such a nature that its decision is a nullity. It may, in perfect good faith, have misconstrued the provisions giving it power to act, so that it failed to deal with the question remitted to it and decided some question which was not remitted to it." The law has moved a long way since the 1960s, but from this case we continue to learn that an error of law by the decision maker provides a basis for challenging an administrative decision.